John, you're on News 96.5. Go ahead.
Hi, good morning. My girlfriend and I are contemplating buying a house together with both our names on the deed.
Okay.
And we were told that we should add the phrase right of survivorship
Well, John,
to that.
first of all, congratulations for calling me and asking me about this, because if you didn't ask me about this, your title company, your closing agent would make up anything they want to and put it there. They might not even ask you what you want, John. So now you have an opportunity to know what the differences are and get it done the way you want it done, John. Okay. So, John, if you have both your names, joint tenants, rights of survivorship, one of you passes away, the survivor would automatically own it all. If you have both of your names and nothing after it, or the words tenants in common, and one of you passes away, that person's 1/2 interest would pass according to that person's will. So, John, how much money are you putting down on this house?
Well, the house is going to be about $400,000, and we each have wills where we leave everything to the other person.
How much are you going to put down on the house?
It'd be a cash buy.
Okay, so you go into this thing, John, with $200,000 into it. John, do you have any children?
None.
Okay, so John, if you're in agreement that if you pass away, your $200,000 of equity automatically goes to your girlfriend, then you're going to put joint tenants' rights of survivorship. Does she have any children?
No, she doesn't.
Okay. So, John, we started this conversation with joint tenants' rights of survivorship. Now you understand what those words mean. If that's what you would like to do, just make sure your title company, your closing agent, puts those words behind the deed.
And those are the words I would use?
Joint tenants' rights of survivorship.
Okay. And you bring up one other question about $400,000 or $200,000 equity. I'm putting up the money. Does she have any tax liability on that, on her half?
Well, I guess in theory you might have gifted her $200,000, and in theory you'd have to file a gift tax return. But, John, checking with your accountant or CPA about that, I'm not overly concerned about it.
Okay, very good.
All right, John. Bye-bye. Hey, John, by the way.
Appreciate it.
Hey, John.
Yes.
How long have you guys been boyfriend, girlfriend?
About 5 years.
Okay. John,
we're both senior citizens, so we both got our heads on straight.
Okay. Well, John, I mean, you are, you're the guy calling me today. Hopefully your girlfriend's not listening, John. But there is another option, John, is that you put the house in your name only. You have a will that says when I die, it goes to my girlfriend. And that's going to, if things really go south, you're going to be in a much better position if that house is in your name only.
Well, that's one of the problems, or that's one of the things I was thinking about concerning the tax liability.
Well, then there's your reason to tell your girlfriend why you're going to put it in your name only, because of the tax liability.
Yeah, and she's very understanding.
So, John, I wish you guys the best, and I'm just giving you just from experience. I've had plenty of boyfriend girlfriends who bought houses together, and man, what happens when they go their own way?
I know.
Okay, John.
Okay.